Hi everyone, hope you all had a lovely weekend. My name's Andrea Panayiotou and I am a family solicitor at RVS Solicitors. As you all know, it was Valentine's Day yesterday, and what might be relative to some of you are the topics that I'm going to cover today. In this webinar, I'll be going over prenuptial agreements, postnuptial agreements, and touching on cohabitation agreements. Some of you have also sent in your current situations, and so I'll be going over how the law applies to you and where we could help. So firstly, what is a prenuptial agreement? So this is a written, formal agreement between two parties prior to their marriage. It sets out ownership of all of their joint assets and individual assets, including the marital home, or what will be the marital home, money, savings, pensions, and debts. And it explains how all of this will be divided in the event of a breakdown of the marriage. Essentially, it gives the couple some certainty when they divorce on how finances will be dealt with. A lot of people say that prenups are predicting that you will get divorced and it's slightly tainting the marriage. However, I would look at it and say that it's in fact ensuring the marriage. I could try and compare this with other types of insurances. For example, car insurance. You wouldn't buy car insurance on the assumption that you will be in an accident, and you wouldn't buy home insurance on the assumption that it will burn down, but you could, prevent the repercussions of these things from being very complicated and difficult. Although you hope to never divorce, it's making it a little bit easier on the off chance that you do. If you have a look in the PowerPoint, you'll see some statistics on the current divorce rates. Last year alone, it was predicted that 60% of couples who get married between the ages of 20 and 25 will end up in divorce. And more than 100,000 people got divorced last year. And I guess that's not what you want to hear if you were proposed to yesterday, but I just want to explain how there is always that chance. I'm sure none of those people last year thought that at the time of getting married, at the time of getting engaged, that their relationship would end up how it did. However, it would be good to make life a little bit easier in the event that you do. So that leads me to my next slide. Why should I get a prenup? I definitely think that it provides peace of mind for both people involved. However, there are specific situations that you definitely want even more clarity on what would happen if things don't work out. For example, you may want to protect inheritance or future inheritance. There may be assets that are difficult to easily split 50-50, such as pensions. You might have children from a previous relationship and want to ensure that some of the marital assets are reserved for them and protect their inheritance rights. You may have a business that's booming and want to retain control of it. If you or your partner has debt, you could include a debt clause to prevent you from being liable at all. And you'll see from my examples that there are many ways to personalise your prenuptial agreement. The prenup doesn't always have to be a strict 50-50 split between both of you. It could be more weighted on one party than the other, and it could also be more weighted entirely onto the children. As lawyers, what we get asked the most is it legally binding? In other words, is it set in stone and can anyone challenge it? Of course, when you watch American TV shows, people assume that the same laws apply to prenups here, which isn't the case at all. At the moment, they aren't legally binding, at least for now. However, following a landmark case, Radmacher and Granatino in 2010, judges are attaching a lot of weight to prenups, and it is likely that they will be upheld unless they're considered to be unfair. If a prenup is unfair, then it would be deemed to be invalid. So, what makes a prenup likely to be upheld? A, the terms of the agreement must be fair and meet the needs of the parties and any dependent children. If this condition is not met, there is little prospect of the agreement being upheld. B, there must be contractual validity. It must be capable of being enforced as a contract. C. No evidence of undue influence or duress. The parties entered into the agreement at their own free will. D. Execution. The agreement must be signed or executed as a deed. E. Timing. The agreement should be prepared and signed a good time before the wedding or civil partnership. The Law Commission report addressing qualifying nuptial agreements recommends that a prenuptial agreement should be entered into at least 28 days prior to the wedding or civil partnership. F. Both parties should disclose full details of their respective financial situations. G. Independent legal advice. Both need to be taken by both parties at the time the agreement was formed to ensure that they fully understand the consequences of the agreement. When a client contacts us explaining that they want a divorce and there is a prenup in place, we will go through the points that I've just mentioned regarding whether it is fair or not. If the client thinks that the prenup was imposed upon them, we'd also look and see if there were any negotiations made at the time of the agreement and see if this adds anything to their case. So those are pretty much the basics of a prenuptial agreement. I'll now be looking at some scenarios that have been sent in to us and where the law will fit into their position. Of course, we won't be revealing any names, so don't worry if your scenario has been mentioned. So firstly, scenario 1. I've gotten married and only decided now that I think we should have gotten a prenup. We've been married for 4 years, and so I'm not sure if this is even something I can do anymore. I don't think that we'll ever get divorced. However, lockdown is making me overthink and consider that I've inherited a lot of money from my late father. And so I'm worried that if my husband and I ever do get divorced, he will get lots of it. I feel that this would be unfair on me. Now, there are some scenarios where people have gotten married and later on either come into some money, such as in this scenario, or thought it might be best to get a prenup for the future ease. We would advise to get what's called now a postnuptial agreement, and effectively this does the same thing as a prenup, but obviously would be signed after the marriage. Again, both parties would need their own lawyers, they would have to provide full financial disclosure and so on. Scenario 2. I'm a second-year fashion design student and my boyfriend, who I've been with for 8 years, is a successful accountant. My boyfriend also comes from a wealthy family and has great career prospects. On Valentine's Day, my boyfriend proposed and naturally I was ecstatic. I've always thought that prenups are a good idea and want to explore my options. I told my friends about this and they assumed that it was the guy who had brought it up, as he was the one with assets or prospective high earning. But I corrected them that it was my idea because I'm going into fashion. I eventually hope to have my own company and know I need to protect myself. I'm a little confused if I can even protect myself when I'm not earning much yet. Does the prenup only apply to rich couples, and should my now fiancé initiate the prenup? Firstly, congratulations on your engagement. I'll look at each of your queries in turn. So you're a little confused as to if you can protect yourself when you're not earning. And of course you can. The prenup is not discriminatory on how much each party is earning, if they're even earning at all. As you are saying you wish to protect your potential business, the prenup will be drafted in a way to review and amend when this occurs. So, for example, if in 5 years' time you create your business, you can draft in a new clause to your prenup to protect this in the event of divorce. You've asked if the prenup only applies to rich couples. Again, it doesn't. The prenup can be less vague and mention that if you do come into property or any assets, that it would be split in a particular way. Therefore, the prenup can account for future property and future debts. In relation to who should initiate the prenup, it can be you or your partner. Both of you would need to instruct your own solicitors, and one side will draft the initial prenup and the other side will review it and negotiate if any terms aren't agreeable. Scenario 3. I've been with my husband for 24 years and we have a prenuptial agreement in place. that we review every 5 years. I've recently found out that he's been having an affair, and I'm wondering if the reason for our separation will affect the prenup. No, not only does the reasons for separating not affect the prenup, but in rare cases won't affect any financial matters in relation to the divorce at all. The only times that this behaviour will be considered is if, for example, your husband gambled away a lot of the marital assets, and in that type of situation, the court may consider this in the financial split. Scenario 4. I entered into a prenup agreement with my husband 4 years ago. It has now come to my attention that my husband, at the time of signing the prenup, misrepresented his career prospects. Other than those mentioned before, there are other considerations that may impact whether a nuptial agreement is upheld, such as evidence of fraud or misrepresentation, at the time the agreement was entered into. However, provided the terms of the agreement are substantially fair and the needs of the parties and the children have been met, the courts are increasingly willing to uphold and or give sufficient weight to nuptial agreements. Scenario 5. My wife and I got married in another country, Spain, 17 years ago, and we had a prenuptial agreement drawn up there. We moved to England around 10 years ago, and when I look at the contents of the prenup and how it was created, although we did exchange financial disclosure and got legal advice, my wife now does not agree with the contents. We are divorcing in the UK. Does our foreign prenup hold any weight? So this scenario is very similar to a case that happened in 2018, Versteg and Versteg. This case involved a Swedish prenup coming before the English court. Similar to the person who has written it in, the wife and husband got married in a foreign country, Sweden, and then moved to England for over 21 years. They then started the divorce proceedings here. On the day before the marriage, the parties signed a prenuptial agreement, constructed in standard terms and executed in accordance with Swedish law. What was interesting is that the wife did not obtain legal advice. While she thought she had understood the terms of the document, she wrongly believed that the agreement applied to and protected non-marital assets only. At the first instance, the wife was awarded a shareholding, a small percentage created by the business and run by the husband under the trust structure, and approximately half of the remaining assets, together all coming to around £51.4 million. The wife appealed. It was her case that the judge should have ignored the prenuptial agreement and in its entirety and instead approached the case as if it were a pure sharing case in which fairness required the wife to receive an equal division of the assets. In particular, the wife argued that she had not received legal advice as to the discretionary approach taken in the English courts with respect to the division of assets on divorce. And in the absence of this advice, that she should not be upheld by the agreement. The decision of the Court of Appeal was, simply put, because the wife had not appreciated the discretionary nature of English regime, it's not enough to disregard the prenup, which was signed in a country where documents are commonplace and legally enforceable. The court found that the wife was well aware of the effect of the prenup and would have known this on divorce, despite not having legal advice at the date of signing the document. Therefore, the foreign prenup was upheld despite the wife not receiving legal advice in Sweden. The court does have some discretion and said that the wife was aware of the full effects of the prenup. If we look at this the other way around, say you have a UK prenup but move country, it's not guaranteed that the country you move to will recognise the UK prenup. So if you do decide to divorce in another country, it's wise to seek legal advice about the impact that it could have on any prenup drawn up in the UK. When you're making your decision, you should consider where the prenup was written and whether it's likely to be recognised by the court in that jurisdiction. It's vital to get legal advice from a specialist international divorce solicitor about which jurisdiction would help you achieve the best outcome for you. Scenario 6. This is the last scenario. My partner and I aren't married, however, I would like to protect our assets that we have acquired jointly and separately. Is there a way we can do this without getting married? Yes. This would be in what's called a cohabitation agreement. If you are living with a partner who is not your spouse, your financial rights will be complex and uncertain. Therefore, similarly to a prenup, the cohabitation agreement sets out what would happen to the assets in the event that you break up and stop living together. The cohabitation agreement is beneficial when trying to establish matters such as who shall pay for the upkeep and bills in a property and how, who owns a share in a property and in what proportions, what will happen in the event of separation, who shall pay certain debts, and who shall be nominated for a death in service benefit. And that is the end of all of the scenarios that I've put together. If any of the information in today's webinar or scenarios I've mentioned is of interest to you, please contact us at RVS Solicitors. I've put my email, I've put Raki's email, who is the director of the firm, our contact number and our website. Thank you for listening, and I hope that was helpful.